Good evening, welcome back. Today we are going to be summarizing Module 19 of the Real Estate Salesperson program delivered by Humber. And if you've not checked out my other videos, please go ahead and do that so you can learn something. And let's get right into summarizing Module 19, Lesson 1. Lesson 1, they talk about additional sale related documents. So there's a lot of pages that you need to go through here, but we are going to skip all the way to the end and read this part. So using an amendment to the agreement of purchase and sale. An amendment is a proposed change to the agreement of purchase and sale that occurs when an offer has been accepted. The proposed change can revise, delete, or add to the original agreement, but must be agreed by both parties in writing to be effective. If the amendment is not accepted within the irrevocable time period, the original terms agreed to remain in effect. An amendment only changes those terms identified. All other agreed upon terms remain the same. Providing a notice. Using a notice of fulfillment. When providing a notice to the other party that a condition has been met, a notice of fulfillment is used. The notice is cross-referenced to the agreement of purchase and sale and includes specific information, including an exact wording of the condition being fulfilled. This must be received by the other party within the due diligence time period identified in the accepted offer. Otherwise, the agreement becomes null and void. If an offer if an offer contains a true condition precedent, only a notice of fulfillment may be used to provide notice to the other party. A waiver is not acceptable. What is a notice of fulfillment? That's the notice that condition has been fulfilled as written. Example, a true condition precedent. Providing a notice using a waiver. When providing a notice to the other party that a condition has not been fulfilled exactly as identified in the accepted offer, however, the party is continuing with the proposed transaction, a waiver is used. The notice is cross-referenced to the agreement of purchase and sale and includes specific information, including an exact wording of the condition being waived. This must be received by the other party within the due diligence time period identified in the accepted offer. Otherwise, the agreement becomes null and void. Okay, since there's a lot of pages here, we're just going to quickly go through and scan them, see if we can find some good information that we need to know. So key components of an amendment to agreement of purchase and sale. An amendment is a proposal or offer to amend the agreement of purchase and sale. It does not avoid the agreement. The amendment adds, deletes, or revises one or more terms previously agreed by the seller and the buyer. Just like an agreement of purchase and sale, an amendment will include an irrevocable time period. If the amendment is not accepted or a counteroffer to the amendment is not made by the other party within the irrevocability, the amendment is null and void, and the term originally agreed to remained in effect. Cool, we know that. All right. We've already read this part. Okay, so basically it doesn't really talk about anything else much. Oh wait, hold on. When a condition has not been fulfilled, meant the party wishes to proceed with the offer, a waiver is used. The following will be required. Cross-reference the waiver, insert the exact clause wording for the condition being waived. The party providing the notice signs and date the notice. The party receiving the notice signs and dates and inserts time when the notice was received. A brokerage representing a seller or buyer may sign the acknowledgement on behalf of the client. When the seller or the buyer is a customer, they must acknowledge receipt of the notice, and as the brokerage is not authorized. Under multiple representation, the brokerage is not authorized to acknowledge receipt of the notice. The acknowledgement must be completed prior to the expiry of the time period provided for in the accepted offer relating to the conditions. So that's for completing a waiver. Alright, let's move on to lesson 2. Lesson 2. In lesson 2, they talk about requirements under REBA relating to a trade. So, disclosure of interest. When a salesperson has a direct or indirect interest in a trade, they must disclose their interest to all parties before an offer. The disclosure must be in writing and includes any fact known that could affect the value, or any subsequent sale or lease of the property that has been negotiated, and any payment that will be made other than what is in a listing or service agreement. Indirect interest. An interest can be any benefit that a restaurant may gain now or in the future from a transaction beyond the remuneration that may or may not stand to earn on the transaction. So for example, if they are trading a property that a seller, the salesperson, the person trading the property is a salesperson's relative or something, so that could be something that you need to disclose, I guess. Considerations for written directions for receiving offers. All offers must be conveyed as soon as possible unless there are written directions from the seller or the buyer to do otherwise. Delaying the offer conveyance may produce preemptive offers. The seller may specify exactly how they should be handled so that the process is fair and transparent for all potential buyers, and the seller makes a fully informed decision. Any change to the written direction must be in writing, and any listing information immediately updated. Anyone who has expressed an interest in the property is to be notified of the change in the written directions. Document retention. REBA has requirements for maintaining copies of documents relating to the offer process. As a salesperson, your activities to ensure compliance include the following: an offer in writing and signed, copies of written offers received that must be retained by the seller's brokerage. This includes any offer that is rejected or countered. The seller's brokerage must retain unsuccessful offers for at least 1 year. A summary document that can be used for unsuccessful offers, but only when a buyer's offer is made through a brokerage. A summary document may not be used when the person making the offer is not a client or a customer of a brokerage. Accepted offers that must be retained in their entirety and submitted to the brokerage. This document must be retained for at least 6 years. Safeguarding information. Maintaining your own file on potential or completed transaction is known as a shadow file. To ensure this type of data collection is permitted by your brokerage, and if so, your activities meet the requirements required to safeguard the information, the following guidelines will help you ensure compliance. Identify the use you intend to make of the personal information. Obtain permission for the data collection and disclosure. A written consent is best. Collect only what is necessary for the uses identified. Disclose information only for the reason it was collected. Implement adequate security at your home to ensure no other person has access to that information. Requirements for a trade record sheet. All activity that results in a trade requires that a transaction file, also known as a trade file, be created, which includes a trade record sheet. As a salesperson, you may not be required to prepare a trade record sheet, as these can be done by the brokerage. However, REBA identifies specific information that must be included. For example, procedures for the preparation, correction, and signature of the salesperson, as well as the review and signing by the broker of record. A brokerage may customize the format and add additional information provided that all minimum requirements are met. A copy of the trade record sheet will be provided to you once the broker of record has reviewed and signed the document. This can be used as confirmation of the remuneration distribution for the trade. In some instances, the trade record sheet documents the remuneration trust agreement for you as a salesperson. So what is a trade record sheet? A brokerage is to keep a trade record sheet with respect to each trade that must comply with REBA regulations by including specific information. A trade record sheet is prepared for every trade and whenever a deposit has been placed in trust, even in situations where an offer is not accepted. A trade record sheet is also completed where a brokerage receives any remuneration related to a trade in real estate, including a referral fees and appraisal fees. So that's lesson 2. Let's move on to lesson 3. Lesson 3 is compliance with requirements under FINTRACT. So FINTRACT compliance requirements. A brokerage must ensure the 5 required elements of a compliance program are established and implemented. These include having a compliance officer, written policies and procedures, completing a risk assessment, written ongoing training, and review of the effectiveness of the program at least every 2 years. As a salesperson, your obligations can be categorized under know your client, 2 reporting, and 3 record keeping. When completing a trade, you must ensure you are complying with the requirements under the Proceeds of Crime, Money Laundering and Terrorist Financing Act. This includes verifying the identity of the seller and buyer, confirming the existence of a corporation or other entity, preparing a client identification report, verifying third parties, and verifying the identity of unrepresented parties. Preparing a receipt of fund record for the money received, completing and submitting to FINTRACT a large cash and virtual currency transactions report when funds received are in cash or virtual currency and total $10,000 or more, or the virtual currency equivalent. Completing and submitting to FINTRACT a suspicious activity report or a terrorist property report, assessing the risk of a client committing money laundering or being involved in terrorist financing. Documenting and monitoring a business relationship once it has been established. Maintaining records, for example, client information, receipt of funds, all submitted reports, unrepresented party, and reasonable measures taken. So these are some of the requirements and that you must comply with. Methods used to verify the identity of an individual. The identity of the seller and buyer involved in the trade must be verified and documented. This can be done directly by you as a salesperson, or an agreement can be signed with an agent, or mandatory to do this on your behalf. This allowable methods of verifying an individual include photo identification using a driver's license or passport, credit file. This must be obtained for a valid Canadian credit reporting agency and not the individual. Dual process. This involves 2 original, valid, and current documents from an independent and reliable source. Verification of a corporation or other identity. When the client is a corporation, you must verify the corporation exists by confirming name of the corporation, corporate address, nature of the principal business, and the names of all directors and names of all beneficial owners. When the client is in another entity, such as a trust, a fund, a partnership, an uncorporated association or organization, you must verify the entity exists by confirming name and address of the entity, the articles of association, partnership agreement, or similar documents, and the name and address of all beneficial owners of the entity. Verification can be done using paper documents or electronic versions. Identify suspicious activity. When there are reasonable grounds to think a transaction is related to money laundering or terrorist financing, a suspicious transaction report must be submitted to FINTRACT. There are many indicators of suspicious activity, but it is generally behavior that is unusual for your client or business. Indicators of suspicious activity can be grouped under various categories. Indicators dealing with payments. This focuses on buyers' activities when providing a deposit. Indicators dealing with the agreement of purchase and sale. This focuses on specific behavior when preparing or negotiating an offer. Indicators dealing with identification. This focuses on both seller and buyers when verifying their identity. Indicators dealing with behavior. This focuses on unusual behavior by a seller or a buyer throughout a transaction. You must be diligent in monitoring and assessing situations to determine any suspicious activity. Mortgage fraud. Mortgage fraud can include falsifying information on a mortgage application about the income, work status, or other employment information. Stating the borrower will reside in the residence when they will not. Obtaining monetary compensation to obtain a mortgage for a specific lender. Being offered an interest rate or mortgage amount that appears very competitive when the borrower has been declined by other lenders. Types of mortgage fraud include straw buyers, falsifying information, identity theft, and value fraud. Leading practices to identify mortgage fraud. Fraud is often difficult to casually detect, but telltale clues are present. This includes value is not supported by market data, things don't add up, unusual circumstances, close connections, unusual requests, or inconsistent facts. Steps to deter mortgage fraud. You have the responsibility to be vigilant about mortgage fraud and help deter potential fraud. Considering the following steps to deter fraud: verify identification, keep clients' information secure, and discuss how identity theft can lead to mortgage fraud. Advise a buyer to only provide a deposit to a lawyer or brokerage and ensure it is held in a trust. Ask the seller for copies of documents that an owner would have. Research the ownership history of the property. Provide copies of the agreement of purchase and sale to the lender or appraiser. Educate your sellers and buyers about suspicious situations that could lead to mortgage fraud. Ensuring accuracy and ethical practices. As a salesperson, you must not knowingly make an inaccurate representation about a trade or services provided. You must not only avoid fraud, error, or misrepresentation, but you must take steps to prevent it. Wow, seems like a lot of responsibilities, but that's what you gotta do. Okay, lesson 4. Putting it all together, a residential agreement of purchase and sale. So, leading practices for the offer preparation. Preparing for the offer process requires a thorough understanding of the agreement of purchase and sale and the ability to explain all preset and inserted clauses. Leading practices include practice presenting the offer, explaining the clauses in simple terms, having the offer reviewed before it is signed, ensuring the sufficient copies of the offer are prepared. Residential transactions. Sellers and buyers expect you to be able to provide advice when submitting or receiving an offer, and to ensure the terms and conditions of any agreement are fully understood before signing an offer. To do this, an understanding of how the preset clauses on an agreement of purchase and sale can impact a seller or a buyer is critical. 4 residential transactions were described in this lesson to illustrate the complexities of an offer. Transaction 1. The easement. Key takeaways: identify the purpose of easement and see if the easement is one that a buyer is obligated to accept. Identify if the easement is considered minor in nature or if it is materially affects the use of the property. Include any acknowledgement in the offer as required. Include any condition in the offer as required to allow the buyer to perform the required due diligence. Transaction 2. The mortgage. Key takeaways in that is, although the seller indicated there is no mortgage on the property, mistakes and misunderstandings can occur Although a survey can appear to be up to date, reviewing the property can identify unexpected concerns which may have been dealt with but not documented, as a buyer might require. A title search date that is close to the completion date does not allow for time to identify and resolve any problems. Include any conditions in the offer as required to allow the buyer to perform the required due diligence. In this instance, a review of the survey. Transaction 3. The redevelopment project. So the key takeaways in this is you have to fully explain the warranties contained within the preset proportion of an agreement of purchase and sale as a misrepresentation. Even though it may appear consensual, excuse me, inconsequential. Oh my goodness, I apologize. I'm gonna skip that word. Can impact a party. Rely on third-party professionals related to the legal, financial, and environmental aspects of the transaction. When changing the use of a property, fully investigate the legal aspects of the transaction to ensure the intended future use of the property can be attained. Environmental concerns can be associated with older structures, as the product and building materials used in the past were not regulated as those being used in more recent construction. And then there's transaction 4, the non-resident seller. A non-resident seller have obligations related to capital gains tax that will impact the net proceeds from the sale. This should be investigated prior to the listing the property. Most renovations require a building permit. Ensure there were obtained. Properties are reassessed periodically. And renovations completed can increase the assessed value, resulting in an increase in property taxes. Ensure the buyer is aware of this potential. Completing the due diligence could be immediately started after an offer has been accepted to allow time should any problems arise for the condition to be completed within the agreed upon time period in the offer. When a brokerage is operating under multiple representation, the brokerage may not give or receive notice on behalf of the seller and the buyer. Obtain their personal information to assist in the delivery of notice. Alright, that was lesson 4. Moving on to lesson 5. Lesson 5 is the summary practice activities. So we're going to skip that and go to module summary, see if we can find any good information that we could use. So yeah, when the agreement has conditions, specifically a condition precedent or true condition precedent clause, and when the condition is fulfilled, a fulfillment notice is provided to the other party. If the condition precedent clause includes a waiver provision and the condition is being waived rather than fulfilled, a waiver notice is provided. When the accepted offer becomes null and void, a mutual release must be signed by the buyer, the seller, and brokerage, releasing them from any obligations and claims in the agreement and detailing how to release the deposit funds. Requirement under REBA related to trade. Disclosure obligation when a salesperson has or will have to have direct or indirect interest in the property. Obligations when a brokerage has received instructions from a seller about receiving offers, and obligations when the instructions change. Requirements for the brokerage to retain documents related to a trade, and for the listing brokerage to retain all offers related to a trade, including unsuccessful ones. Required for a brokerage to complete and retain a trade record sheet for every trade. Okay. Compliance under FinTract. So basically, make sure there is no money laundering or no terrorist financing. Make sure your obligations in the brokerage are naming a compliance officer who is responsible for brokerage compliance, having written compliance policies and procedures, provide training to everyone acting on its behalf. So basically, 3 obligations for a salesperson is to know your client, reporting to FinTract, and record keeping. So in knowing your clients, understand your client identity, and irregular or suspicious activity or transactions, assert client identity, verify the existence of their identity, determine a third-party involvement if the third party, or a report on measures taken for identification if unable to do so. Monitor ongoing business relationships and reporting to FinTrack. Make sure you report any suspicious transaction or any large cash transaction, any large virtual currency transaction, any terrorist property report. Record keeping. Make sure you keep your client's information. Make sure you keep all your client's information, receipt of funds, and all submitted reports, and reasonable measures have to be taken. And putting it all together, use leading practices to ensure you are able to explain to a buyer and seller any preset clause or clauses added to the agreement of purchase and sale. This includes providing advice when submitting or receiving an offer, and explain how a clause can impact a seller or buyer. So that was module 19. I hope you learned something. If you have, please give me a like and comment, subscribe, share, whatever you want to do. And I'm joking. But yeah, anyways, thank you guys. Thank you for listening. I hope you got some information done. I will be doing module 20 soon, and I do have an exam coming up soon, so wish me luck and good night. Thank you.